and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest is Carliss Chatman, Assistant Professor of Law at Washington and Lee University School of Law. We will discuss her article, Myth of the Attorney Whistleblower, which will be published in the SMU Law Review. So welcome to the show, Carliss.
Thank you. Thank you so much for having me.
Yeah, the pleasure's all mine. This is a really interesting paper, especially for me, because I just started teaching professional responsibility last year and, have been engaging for the first time as an academic with a lot of the topics and problems that you're discussing in the article. And I found it really illuminating in a lot of respects. So thanks a lot. I'll be using it in class and including it in my casebook.
Thank you. A reason I wrote the article is because I was teaching PR and I read about Rule 1.13 Sarbanes and the interplay of the rule changes and the process. And I discovered that there were no enforcements, no litigation. I talk about those rules as a cautionary tale to my students. And, all the PR books talk about the threat of the sanctions and the threat of jail time and how, attorneys are found to collude and found to not have disclosed how much trouble they can get in. But, every time I teach PR, students are like, well, where's the case about this? You're giving me this big bad threat, where's the case? And, this passed in 2002 and there are none. And so, in the law, zero is a funny result. We were not used to zeros.
Yeah, no, it's interesting. I mean, it's like the dog that didn't bark conveys a lot of information about kind of what's actually going on in the legal landscape.
Yeah. I do have the unique experience of having worked at Vincent and Elkins too. And so, it's hard having worked at the firm that represented Enron and knowing that some things changed, but others didn't afterwards. But I'm making this huge threat about a statute in class. And, it's like the legal scholarship doesn't seem to match the reality. So I was trying to really reconcile it.
Well, so Carliss, for listeners who may not have engaged as directly in professional responsibility questions recently, or for listeners like students, for example, who may not have actually taken a professional responsibility class yet, I wonder if you could talk a little bit in general about the nature of the attorney-client relationship and the duties of confidentiality and privilege. Sort of what are those and what kinds of obligations do they put on an attorney in relation to the client?
Okay, yeah. So in the Model Rules of Professional Conduct, there are several rules that emphasize that the person who retains you, the person who hires you, is the client. And it gets confusing when you represent a business, because if you represent a business, especially a big corporation, a corporation is a legal person, but it's not a physical person. So you are going to be interacting with representatives of the company. And so what Rule 1.13 wants to remind you is your client is not that person who you see every day. It's not your friend from law school who called you up to retain you on a matter. The client is the company, and you are representing the interests of the shareholders and the other stakeholders of the company. You are not supposed to form a personal relationship with the individual who hired you. The other thing that gets woven into Rule 1.13 and the Sarbanes changes is that when you represent a client, all of the information you learn belongs to that client. You owe that client a duty of confidentiality, and then you also are protected by the attorney-client privilege under the rules of evidence. And so if things are happening within the company or you learn things about your client, under almost every circumstance, you are not supposed to disclose. And there are lots of fun cases in PR about, like, I think I teach the book that has the kidnapping case where they refused to say where the bodies were buried. And, the lawyers had people coming to their house and sending death threats because they wouldn't tell. But, if they would have told the police where the clients told them the bodies were, they would have been in breach of they may have gotten disbarred. And so what 1.6 and what Sarbanes does is create these opportunities where an attorney should first report up the chain if they learn of the company, someone who works in the company doing something wrong. You're supposed to report to management. management should investigate. If management doesn't investigate, then you report to the board. And then in extreme circumstances, you have the right to report externally if it would hurt the value of the company or if it could impact the stock market. And so that change, the ability to report externally and that exception, is what made everyone be up in arms about the Sarbanes changes and what made everyone up in arms about the changes to 1.6 and 1.13. The idea that your attorney could tell on you was just, ingrained in, 200 plus years of jurisprudence. And so the idea that we would create this exception was just so extreme.
Mm-hmm. Well, so setting aside Sarbanes-Oxley and the changes that came along with it, which I want to talk about in a moment, are there circumstances in general where attorneys might be able to disclose confidential or privileged information despite the attorney-client relationship? I mean, I understand that they're pretty all-encompassing, but are there existing exceptions, and what kinds of exceptions would there be?
There are some existing exceptions, but they're pretty limited. The most important thing to remember about confidentiality, I try to teach it. I talk to students about like a time-space continuum. You can never disclose something your client did in the past. So, if your client did something in the past, you can never disclose it. If you think they are going to do something that will result in certain death or bodily harm, you can disclose it. I guess crime and fraud is one of the changes, but crime and fraud has always been an exception. Like if you think they're about to commit crime or fraud, but if they're currently committing a crime or fraud that's going to create financial injury, then, I think that one's fuzzy. I haven't seen any cases that say it. Anytime your client is using your services currently to commit a crime or fraud, you can disclose that. But if they used your services in the past, you can't disclose it. And then you can get legal advice about compliance with the rules, but like if you call the ethics board, but it's my understanding, I've had friends who've called the ethics board before, like they will tell you they'll keep it confidential. So, that or if you need to defend yourself, you can disclose it. But those exceptions are so limited and so rare that, the way that they're designed is you want to develop a relationship of trust between you and the client. You want your client to tell you the truth. And if your client thinks you are going to go tell the SEC or you're going to go tell the police, they may not be honest with you completely. And then it's impossible to, I don't do criminal defense, but, it's impossible to defend someone criminally if you show up at trial and you get surprised with evidence. It's impossible to try a lawsuit or take a deposition if a witness pops up and comes out with new documents and new facts. And so the best way to zealously represent your client and to give them service is to know all the information. We can't practice law in a vacuum, and all of our opinions are so fact dependent that if we don't have this open communication with the client, if we don't have this open relationship of trust, then it inhibits our ability to practice law. And that's the spirit of the rules. And so, when these changes to 1.6 were adopted and when Sarbanes was adopted, there are just all these white papers and comments from practitioners who give a warning that basically says, even if this never gets enforced, the mere idea that an attorney could go to the authorities might have a chilling effect on the attorney-client relationship. And it's a hard thing to measure. There are some things, I'm thinking about an empirical study in a couple of years, talking with the ABA and talking with like in-house counsel to see if I can measure a change in behavior. But, it's hard to tell when your client's not being honest with you because they think that you might tell on them. And it's, I think the biggest change, the change that I anticipate is I think people are hiring lawyers less, especially in-house and especially at startups and at corporations. And I think, some of these rules, some of this compliance could be why.
Earlier in our conversation, you mentioned that when a lawyer is retained by a business entity like a corporation, the lawyer represents the corporation and not the agents or employees of the corporation. Um, in your paper, you talked about sort of how, in a lot of ways, that seems to sort of complicate the relationship between the attorney and the client, in the sense that the attorneys might not be necessarily privy to all of the relevant information. They may not have the context to understand the information. And as you just kind of suggested, companies or entities may actually hire attorneys to sort of do very discrete things rather than represent them sort of across a range of different activities that would enable the attorneys to kind of understand the broader business practices in context. How does that make it more difficult for attorneys to engage in any kind of oversight or whistleblower type activity?
So the changes in Sarbanes require that when an attorney reports externally, that they have actual knowledge of wrongdoing. And, most law students know actual knowledge is like the most difficult standard ever. How can you actually have knowledge of anything that's in someone else's head? And how do you have knowledge of someone else's intentions? And when we're talking about corporate fraud, intent is a major element of every type of corporate fraud. It's an element of every fiduciary duty. And so for you to disclose externally, if you're going to report to the SEC, you need to have knowledge based on your reasonable legal belief that, your client is engaged in wrongdoing. And, I practiced for 11 years and I can't say I ever had actual knowledge of anything my client was doing. I think it's almost hard to say I had a reasonable belief about what exactly my client was doing. And one reason why I think I feel that way is because of a phenomenon in the article I call practicing law with your head in the sand and in the silos. For a few decades, like there's a book that's written in the 80s that I cite, and then they updated it later after the passage of 1.13 in Sarbanes. But, since the 80s, it's been the trend in the legal practice that we specialize. And you notice it amongst law professors. Like, we can't all teach all the first year classes anymore because, if you came from practice, you specialized. If you went straight into academia, you specialized in one area. The mere fact that you can't just have any law professor walk into any classroom tells the story. And that continues through practice where, you kind of focus on what you're going to focus on in law school. You focus on what you're going to focus on in your first job. And the goal is to become an expert in that one area so that you can charge the highest rates, so that it's worth retaining you because you're the expert and you can get the work done the most efficient and the best way. The problem with that is if I am a tax expert and the fraud is based on corporate governance, I don't have actual knowledge because I'm not a corporate governance expert. Or if I am a tort lawyer and it's a tax fraud problem, I don't have the knowledge to understand what a tax fraud problem is. And I think that's a genuine lack of understanding. I really don't think attorneys are faking that. I tell my students after you know the most when you take the bar exam, like, the most about the most areas of laws that day you take the bar exam. And then I would say within a year or two of practice, I just started to forget areas of law that I wasn't practicing in. And the longer I teach, the more I forget things that I practice, but that I don't teach anymore. And so, you just get so in the weeds about one topic that it's hard to issue spot outside of your area of law. And if the standard for external reporting is you have actual knowledge, I could never have actual knowledge about tax fraud because I don't understand tax enough. The other thing I call is burying your head in the sand. If you are retained to work on just tort matters, you are inefficient if you go digging around for securities cases. You are overbilling your client if you go digging around for tax problems. And so to be efficient and in compliance with other rules, if you see something and just your gut tells you it's fishy, but you don't know, the right thing to do is actually ignore it, not to bill for it or to take your time digging further when it may be nothing because you don't have the level of expertise.
People in our position remember that the Enron fraud and bankruptcy were sort of a precipitating event in Sarbanes-Oxley and various reformations of attorney responsibilities that you're talking about in this paper. But I think a lot of listeners might not be that familiar with Enron or might have kind of forgotten some of the details. So I wonder if you could briefly kind of outline what happened with respect to the Enron fraud and bankruptcy, and specifically what role did the lawyers play in that event?
So Enron happened in 2001 is when they discovered that there was a problem. And what I find most interesting about Enron is that the way the fraud was uncovered was that some journalists at the Wall Street Journal Dallas office actually read the footnotes of their financial statements. And so I like to call it fraud in plain sight. Like, they told everyone that they were using a form of accounting that's not allowed anymore, that they were using special purpose entities, which they formed limited partnerships and limited liability corporations, basically for the purpose of putting debt and other things off books so that it wouldn't get reported in their like quarterly and annual SEC filings. And so they would look good to the market. They looked better to the market than they were because of their usage of these side entities, which made them have exponential growth higher than any other company ever of all time. And that also made them, I think, 6 months before the fraud was uncovered, Forbes called them like one of the most innovative companies. And they're like, touted as a market darling. And all it took was for a Wall Street Journal reporter to actually read the footnotes to realize that it's like, hey guys, we're not actually seeing everything in these financial statements. Once people started digging behind the surface, and the reason I think, the entity structure and the use of attorneys is so fascinating is that they were forming these limited partnerships off books, and they would usually have a manager or employee be the managing partner of the limited partnership and get a fee. And they would put loans and bad assets in these limited partnerships, but Enron, the parent, would guarantee the loan. And because Enron, the parent, was guaranteeing the loans to these entities, they could convince banks to lend to these entities with no credit history because of the reputation of Enron. So it was like they would create an entity to get things off books, use the fact that Enron's credit rating is going up because they suddenly have less debt, then borrow money in this entity and use Enron's credit history to back the loan. And then they could get another loan because they just put more debt off books. So it's like this like crazy circle of moving money around just on paper, but not in reality. And, with the attorneys, where the attorneys were involved, and this is why I talk about head in the sand and silos, even though there were two major law firms working on it, Andrews, Kurth, and Vincent and Elkins, the tax department was working on part of it. The corporate department was working on some things. Arthur Andersen is working on other things. And so, the lawyers are being asked to issue true sale opinions, or they're being asked to represent the individual limited partnership, or some lawyers are being asked to represent Enron parent. But, each of those limited partnerships is a different person legally. So those lawyers don't have the right to report out to Enron parent because it's a separate person unless there's a joint defense agreement there. And then the tax specialist is not asking questions about conflicts of interest and governance that the corporate person is asking about. The corporate governance person is not asking about what happens if the tax people give an opinion that allows for this sale and allows for this accounting. You just you have the attorneys in their specialty silos not talking to each other. And so what made people so upset about it, John Edwards made a last minute addition on the floor of Congress. And that's how we ended up with the Sarbanes changes, is that even though, Arthur Andersen fell apart, people at Arthur Andersen are convicted, people at Enron are convicted, no lawyers are convicted because they're not collaborating in the fraud. None of all the lawyers who were at the law firms claimed they did not know because they were practicing in their individual silos. And so while, I believe there was a malpractice action and maybe it settled, I don't think anyone had any disciplinary actions taken against them at any of the law firms, other than the lawyers who were at Enron and actually partners in the entities and obviously involved. But the lawyers who were external, who were just working on things a matter at a time, basically said, we don't have enough knowledge. We didn't know what all was going on. We couldn't see the whole pie. We only represented this small piece of the puzzle. And so what I found most interesting about the changes is that, Sarbanes goes ahead and relies on the idea that an attorney would have knowledge, but they don't make any change to the structure in the way that attorneys represent clients and in the way we define clients. And so you make a change and you impose it on the exact same system. I just think it makes the system stronger. It makes us more likely to silo. And it gives me an incentive to bury my head in the sand, because if I don't know, I can't report what I don't know.
Yeah. Well, so maybe you could talk specifically about exactly what changes did Congress make in Sarbanes-Oxley in relation to the disclosure obligations it wanted to put on lawyers, kind of to the best of to the best we can kind of pin it down. What did Congress think it was gonna achieve with these changes, and sort of what, if anything, actually happened? How in practice did lawyers actually react to them? You've talked about that a little bit, but maybe sort of if you could flesh out exactly sort of what Congress was expecting or what Congress was hoping to accomplish as compared to what the kind of real world implications were.
I struggle with trying to figure out what Congress was actually trying to accomplish, because it's one of those things where it's like, why'd you even write this? Which happens a lot when you read about Congress, right? But, so I think John Edwards wanted his moment, first of all. And I think attorneys were the only party left off the menu in Sarbanes. And their solution was to give the SEC the authority to amend the rules governing lawyers who practice before the SEC to have more oversight. It was just SEC, y'all are the experts about what you need. We give you the authority to govern lawyers. Well, the problem is that just like corporate governance is state law, how a corporation is formed, what fiduciary duties mean, that is state law. And so when you impose the securities regime on that, you've got a lot of kind of after the fact monitoring of companies, because the SEC can't go in and say, this is who needs to be on your board of directors, but they can say, these are the reports you need to give us. The SEC can protect the capital market, but they can't go in and invade the domain of the states and change what happens inside a corporation. The exact same problem happens with lawyers. The governance of lawyers is not federal. It's state by state. You take a state bar, you don't take a United States bar exam. And because of that, the SEC has always deferred to individual state bars for the governance of lawyers. And so when they had the comment period open, the SEC made a lot of points of saying, we're not invading the domain of the states. And I'm sure they anticipated some state bars getting together and suing them. And that may be why they did it. And so they write it in a way that I think has no teeth. And so, the first element of what the SEC did is say, you must be an attorney appearing or practicing before the SEC representing an issuer. And when companies have these nested entities where Enron had, where it's a parent corporation and a bunch of subsidiary corporations, the issuer is just Enron. So if you are the attorney for the special purpose entity, you are not governed by the SEC rule. So that eliminates all of those attorneys who are representing special purpose entities. Then it's only the attorneys representing Enron. And what it then does is impose this regime of reporting up the chain. So you discover something, you tell that person's supervisor, the supervisor should investigate and follow protocol. You can also go to a Part 205 compliance committee. You can have a compliance committee internally that you report to at a company. If those people do not satisfy you as an attorney, then you can keep going up the chain as high as the board. And you are only allowed to report externally if you believe that they are, one, violating SEC rules, and that it will do harm to the market and harm to the company. And that's where that knowledge standard comes in. And so that only applied to attorneys practicing before the SEC. And, based on what I've read about the dialogue amongst, lawyers and the ABA, there was some anxiety that, the feds could continue to invade their domain. And so in response, the ABA amended 1.6 and 1.13 to essentially do the same and then apply it to all lawyers. And it basically is the same kind of up the chain external scheme, but it relies on the definition of entities as defined by state law, which again means if you represent that subsidiary and not the parent, you don't get to break privilege and go talk to the parent. If you think the fraud is happening amongst if you think the employee of Enron is the manager of this partnership and they are colluding with another employee of Enron, you don't get to go tell if you are representing the limited partnership. And so, the real problem is I feel like there was so much focus on this feeling that the attorneys knew something. And if the attorneys would have told someone something externally, we could have stopped it. There was a lot of focus on giving attorneys the right to speak, but there was a complete disregard for the way states define attorney-client relationships and a complete disregard for the way states define entities. And I think that's how you get to over 15 years and no enforcement, nothing reported that we can find, because it's an impossible standard to meet. The other thing that's interesting is if you do not follow the protocol found in Sarbanes, meaning that you have to report to the SEC first. So if you just called up the New York Times instead of reporting to the SEC, you don't get you don't get whistleblower bounties, and you don't get whistleblower protection. So it eliminates the financial incentive. Like if you think, you know what, I'm just going to call up a reporter and be a quiet whistleblower and get it out to the press. Honestly, I think that might do more good. But if your company finds out you did it, or your client finds out you did that, you have zero protection and no bounty if the government's able to recover. So it's like they've eliminated all the incentives. They've hurt the attorney-client relationship because of the mere possibility. And it seems to not have changed anything. So, a lot of people have said as they've read this paper, well, if it doesn't do anything, what's the harm? And I'm like, well, a law that doesn't do anything is always harmful. Like, why do we have laws that do nothing? Especially if they can change behavior.
Well, so one thing that really helped me sort of wrap my head around the sort of consequences of the argument you're making were the examples that you offered. And I thought one was especially nice because of the Wall Street Journal parallel, right? So the much more recent Theranos bankruptcy and collapse was, of course, also exposed by a Wall Street Journal reporter. And you used that, I think, as a really powerful example of how, the desire to encourage attorney whistleblowers to step forward doesn't seem to have played any role in the Theranos debacle. And in fact, to the extent there were whistleblowers, they were non-attorney whistleblowers. So I wonder if you could just talk about that briefly as sort of like an illustration of the points that you're making.
Yeah, I find Theranos fascinating because Elizabeth Holmes was smart enough to hire attorneys from the outset. There are attorneys there from day one. And to me, it looked like attorneys were involved. And I have my students tracking the Theranos litigation, my RAs. There's nothing happening against any of the attorneys at Theranos, either at state bars or in the SEC prosecution of Elizabeth Holmes. The first in-house attorney at Theranos quit because he didn't like what was going on and was suspicious, didn't believe in their claim that they didn't need to report to the FDA. Attorneys were actually used to help, squash some of these whistleblowers directly. They threaten to sue people all the time. They sent demand letters all the time. You see attorneys there at every step of the way, but you don't see any attorneys reporting anything. The other thing that other way that Theranos is interesting is they showed this unicorn phenomenon of, this is a private entity, so the SEC rule doesn't apply to them at all. This company's not an issuer under the SEC. And so, that whole element of it is eliminated. We still have billions of dollars of fraud, the whole SEC element that Sarbanes was intended to address is eliminated. All we really have to get attorneys to be whistleblowers are the model rules of professional conduct, which seem to have done nothing. And yet we have just billions of dollars of fraud, people losing their retirement savings. One of the guys committed suicide. It's just, probably the biggest scandal of the last 10 years. Attorneys are there at every step, yet none of the things that Sarbanes intended to do, or that, the changes in the model rules intended to do, have happened. The other example I use is Tesla, because I find it fascinating that, that Elon Musk is doing all of these things, and there seem to be no attorneys around. I know their general counsel quit in the middle of the most recent SEC issues, but if what this was intended to do was to make attorneys gatekeepers inside of a company, and to keep people in check, and to hopefully make them more in compliance with SEC regulations, it's like they can't even stop the guy from tweeting. So, how can an in-house attorney possibly, stop someone from committing corporate fraud? I think both cases illustrate the limits of attorney power. I think that, there's some perception that we have this element of control over our clients, or, that our superior knowledge and our legal knowledge can help them make better business decisions, but that's just not the case.
Well, so Carliss, in closing, I think you've made the case pretty powerfully that the attorney whistleblower provisions of Sarbanes-Oxley have proven to be toothless, if not totally irrelevant. But I'm wondering if you have any thoughts about what can and should we do, if anything, around those around this kind of set of concerns. Is there a legislative or regulatory fix that might be more effective, or is this just something that we should walk away from and realize that it's not going to work?
I tend to think expecting attorneys to blow the whistle is a bit ridiculous. Keeping secrets is how we make our money. And so if we are no longer secret keepers, we begin to become obsolete. But I think there are ways to accomplish what Congress wanted without requiring attorneys to ever report externally. And I think that is actually the domain of state law. I think that, if states change the way we treat, I call it corporate families in my next paper. If we change the way we treat a company like Enron that is structurally complex solely for the purpose of committing fraud, if those attorneys are allowed to communicate between entities, because we say you look instead at who are you benefiting in the long run, like if everyone is operating for the good of Enron parent, then the top of the chain for all of the little limited partnerships and LLCs is Enron parent. And you would treat it as a family relationship where you can communicate outside of the limited partnership all the way up to the board of Enron, instead of just to the manager at the limited partnership who is the one committing the fraud. So I call that paper breaking silos. The other thing, so I would consider changing. I think that takes a change to the rules, the corporate governance rules in an individual state. So the change to the Model Business Corporations Act, in that, changing it so that we characterize a corporate family as a family for communication purposes, and for attorney-client relationships and possibly other experts and possible gatekeepers. If you're retained, we're going to look at who is the real party in interest. And I borrow from real party in interest from CivPro. There are times in CivPro when a union can sue on behalf of a union member. And there are some other circumstances in civil procedure where, you can sue in someone else's name. So I think we just borrow that for corporate governance and recognize that, if you're doing what Elon Musk is doing, which is treating, Tesla, Solar City, and SpaceX as his personal empire, even though he doesn't own a controlling interest in all three of them, you can treat that as a corporate family for, attorneys who are representing multiple entities, for experts who are representing the multiple entities. And I think that gets at the concealment of information that happened. I also think that if we start to treat entities as families when they present themselves that way to the public, that could alter the SEC reporting. And so maybe we would have seen the balance sheets of these special purpose entities and saw that they were all debt and that, no entity other than Enron parent was making a profit and all the other entities were running at a loss. If I'm an investor, that's information that I want that I don't have under the current system. One company I've been looking into is Live Nation, which I learned has 753 affiliated entities. So no single entity is important enough to end up on their SEC filings. And, I just wonder, are any of those entities special purpose entities like Enron had that are just vehicles for debt? And we just wouldn't know.
Carliss, thanks so much. This has been a really fascinating conversation. And I've learned a lot about Sarbanes-Oxley and the attorney whistleblower provisions.
Yeah, thank you so much for having me. It's good when people care about PR, right? We want our students to be and
it matters, man.
It does. It's the class that people, dread taking and just feel like it's obligated, but it has so much impact on our lives. And, I hope to write more in the PR space to bring attention to it.
Sure, floating in springs, in lakes and the streams. The Indians used it for a medicine cure, but never in the wildest of dreams did anyone think that black sticky stuff, always in short supply, would ever have power enough to gush its way to the sky. When the bubble and grew as his drill cut through the soil. Up came oil. Up came oil.
Spindletop turned it around. The world soon saw just what oil could mean. Starting off slow, blowing out of the ground, then refining that crude to pure kerosene.
Oh, we really started cracking with a process devised when a guy named Burton appeared. The history of oil has kept us all surprised, cause it's only been 100 years since oil came oil. Oil came oil. Industries stood right on, serving home in the farm. It caused the melting pot to boil. When